Hello, welcome to the Black Women Lawyers Presents the People's Law School virtual edition. Today we're addressing the state of the courts in Michigan. We want to educate the public regarding what's going on with the courts. As we all know, we're in uncharted waters with this pandemic, and it's changing a lot of things that operate in the state. One of those things being how the courts operate. Today we have on our panel for you to bring information to you is ZENELL Brown. She's Executive Court Administrator for Third Circuit Court. And she'll be talking about issues that are affecting Third Court and Wayne County courts. And she may be able to share things with you for the overall court view in the state. We also have attorney Lisa Timmons, also from Third Circuit Court. She's an executive director at the Mediation Tribunal, and she'll be bringing you information regarding mediation as well as case evaluation. We also have attorney Mary Bowen, who is an assistant city attorney with the city of Lansing, and she'll be bringing you information of what's happening in our state's capital. Thank you, ladies, for agreeing to be on the panel. I would like to start the panel discussion off with the court executive, ZENELL Brown. ZENELL?
Thank you for having me, Chandrika. As you said, we're at the Third Circuit Court, and definitely this is uncharted waters. So I wanted to do some general updates and then talk about some different things that are going on in the various divisions of the court. So just to start off, definitely if you're looking to see what's the latest as far as the court orders, as far as operation, please visit our website. It's 3rdcc.org. I will give you 3 numbers that are probably pretty good to have in case you have any other questions. If you're looking for something for court administration, it's 313-224-2561. If it's something in our criminal division, 313-224-2437. If it's our domestic relations division, 313-224-6639. And let me also add the juvenile division to that list, 313-833-4777. So those are definitely numbers you want to keep handy. Today, as far as May 1st, this marks the beginning of when everybody can bring a cell phone or electronic device into the court. And the ironic part about that is that the court is closed to the public, so no one's actually bringing those in as of yet. But definitely this is a new era for the court, along with the Zoom use and everything like that. Our staffing is now returning to the court, but we're not open for the public, like I said. We want to make sure that we're having an opportunity to address some backlogs. We're using staggered hours and making sure that we're practicing social distancing, working with our mask on and everything like that at the moment. Attorneys, at this point, I would say you probably want to make sure that we have your email. So when you're filing something, include your email addresses when you're filing it, because the court wants to use those type of things to help connect to schedule Zoom hearings. Most of the hearings will start back May 11th. Some are in process now in various divisions, but make sure when you're filing, we definitely have your email address so we can stay in contact to let you know how we're scheduling and what platform we'll be having your hearings on. As far as juries, we've already made the decision. We will not have any jury trials until mid-August. We're thinking August 17th, but we will let the medical experts and the public health officials help guide us along that route there. Now let's turn to the divisions. Let's start off with civil. As you can imagine, it's a lot easier for the civil judges to adapt to the Zoom world based on the type of matters that they have, settlement conferences, that type of thing. They can actually do a lot of work one-on-one with attorneys. And our civil division is working remotely to actually do that. Any matters that were scheduled in the civil division prior to the pandemic will automatically be rescheduled. So stay on the lookout for those notices. It'll be an IT project that will actually make sure that those notices get printed and delivered to counsel as well as the parties. For our criminal division, first of all, let me acknowledge them because they were the first division within the court that started using the Zoom. So they're actually having their daily dockets posted on our website. And for public access, you can actually click in and watch the video on the YouTube channel that the court has established for those. One other thing I think is really important in our civil division is what the court has done to work with the prosecutors and defense bar to reduce the jail population during the pandemic, to make sure that those who did not pose a public threat were not being housed in the jail, released either on tether or personal recognizance for a future court date. And finally, if you don't know, we do have a new judge. Judge Darnella Williams joined the criminal division this month as well, or last month in May. For our juvenile division, again, we're using Zoom and telephones to stay in contact with counsel, to conduct hearings, to conduct meetings, and it's basically working very well. We're very proud of what we're doing in our specialty court divisions there, whether it's the drug court, the juvenile mental health court, or our CASA program, where we even have volunteers who are reaching out to stay in contact to make sure that juvenile justice is still delivered. Now I get to turn to one of my favorite areas, which is domestic relations and family. And of course, there's a lot going on there. For attorneys, if you have a friend of the court question, there is a friend of the court hotline available for attorneys. The number is 313-224-5295. And I'll repeat that number, 313-224-5295. You can also reach out if you're an attorney at the friend of the court hotline, FOC attorney line at 3rdcc.org. For child support payments, the Michigan Disbursement Unit is still taking inquiries there. Child support payments are still being processed. So if you do have a child support order and you're not on an income withholding, make sure you're making those payments. If you do need to ask for a modification or review of that order, make sure you file the appropriate request or motion to get that done as well. The family division will probably resume hearings around May 11th. Again, that's going to be remote hearings. It's also going to include interviews by the Family Assessment and Mediation Division through Zoom for families. So expect to hear more for that, and stay tuned to the website for that. One of the things that was urgent during the pandemic is making sure that PPOs had a way to get to the judges. So there are new PPO instructions where you can file a PPO and you can do it electronically, and that too is available on the website. We want to make sure that no one is subjected to harm because of the stay-in-place orders and the reduced court services. Finally, what's coming up is a lot of questions about the stimulus check and what to do with parenting time. So with the government stimulus check, if a payer owes $150 and the custodial parent is receiving state benefits, the stimulus check will be intercepted. If the payer owes $500 and there's no public assistance involved, those stimulus checks will be intercepted as well. If it's a joint tax household, a joint filing, the payment will go on a 6-month hold, and that allows the injured spouse to file a claim to reclaim their portion of that. If it is a single filing person who's the payer, the money automatically flows through the friend of the court, the Michigan Disbursement Unit, and then out to the Public Assistance Agency or to the custodial parent. It is something to note that the Federal Office of Child Support has made a request that if there are future stimulus payments, that those are not intercepted for child support payments. So that those would actually go to the payors. Just to turn our attention to parenting time and custody orders at this point, it is very important to know that we are still expecting parents to abide by the orders that are in place. We realize that there may be some circumstances where it's not feasible or the parents' schedules have changed where they can't do that. So we're asking that parents reasonably work together. We definitely believe if you're modifying what the existing order is, you should have something in writing where both parties have signed off. So if that becomes an issue of dispute, you can show that to the judge as well. And I believe that that basically takes me to the end of the quick overviews for the court. Like I said, if there's any other updates, you'll find them on our website, 3rdcc.org. The court has been working diligently to make sure that we're gearing back up to offer services. And currently we're offering the most services we can remotely. But stay tuned to our website, check us out on our social media, and the updates will be available there. So thank you again for having me.
Thank you so much, ZENELL. I appreciate you. You gave a great overview. Lisa, would you like to chime in and give us an update regarding mediation and case evaluation?
Sure. Thank you for having me, Chandrika. The Mediation Tribunal is a private nonprofit agency, and we are a service provider for Wayne County Circuit Court, the U.S. District Courts, and some of our local district courts in the county of Wayne. We provide case evaluation of civil cases. So a typical year for us is about 6,000 to 8,000 hearings. So based on the need to do social distancing, we have decided that that's not practical or something that we can do in person for the foreseeable future until there's a better hold on this pandemic. So we are moving our cases remotely, remote hearings, utilizing Zoom virtual hearing rooms, much like the court has done for their judges. They've done built these virtual courtrooms where attorneys can be in a waiting room, wait for their turn, be called into the Zoom room. It even allows breakout rooms. So the best updates for the Mediation Tribunal and case evaluation right now is our website at www.mediationtribunal.org. The best contact right now is to email me, and that's Lisa, Lisa.Timmons, Timmons, at 3rdcc.org. Shortly, we will have, hopefully sometime today, we're going to have a list of the employees with all their email addresses and some temporary phone numbers where you can reach everyone remotely. So our status is, based on what ZENELL touched on, the Chief Judge at Wayne County Circuit Court did an automatic 60-day adjournment of every civil scheduling order on March 23rd. What that means for us is that the very earliest case we should have evaluated had it not been for the pandemic would have been on March 16th. So those cases are being rescheduled now, and they are scheduled to go hopefully on May 18th. We're going to start running panels 5 days a week, 4 panels a day, with only about 10 cases a day on each panel, just so that everyone can get a level of familiarity with Zoom and how this is all going to work for us. As everybody's used the same phrase, this is uncharted territory, but it's kind of forced us to think outside of the box and think in a way that we can work so that we can protect our staff, protect the case evaluators, the many attorneys that contract with us, and then the public, the attorneys, the counsel, everyone coming into the office. Just quickly, some people know that the Mediation Tribunal was the first agency to start to launch an online database for uploading summaries and getting awards. So we're trying to be on the forefront again of doing remote case eval. If anything good comes out of this pandemic, then it's the fact that it's kind of given everybody a push to think in a new way about how to handle cases, hearings, and evaluations. So just to summarize, we had to honor the 60-day adjournment of the chief judge. So every case evaluation is considered a scheduling date. So whatever case evaluation date you had, expect an automatic 60-day adjournment. You don't need to file an adjournment order with the court because the court is already dealing with enough orders and scheduling and things on its own without additional orders. That's automatic. You will expect to see notices from us coming out soon. We anticipate starting case evaluation on May 18th. All of our hearings will be remote until further notice. There is a Zoom link that our IT group is building right into the case database. So when you log into the case, you can go into your Zoom room, and we hope to have that on our notices as well. And contacting us, keep checking our website at mediationtribunal.org. And if you just email me, I will get it to the right person at lisa.timmons@3rdcc.org. Thank you.
Thank you so much, Lisa, for that great overview regarding case evaluation and mediation. Mary Bowen, could you give us an overview of what's happening in the city of Lansing?
Hello, everyone. As briefly mentioned, I am an assistant city attorney with the city of Lansing. As an assistant city attorney, of course, I am representing the city either as a prosecutor or defending the city against legal actions or bringing legal actions on behalf of the city. Because the city handles a lot of district court work in addition to circuit court work, a lot of what I'm going to talk about is going to deal with the district courts. As you know, a lot of our landlord-tenant and our criminal cases, they all originate from the district court. We have several district courts in the Lansing area. There's 54A, 54B. 54A is the city of Lansing. 54B is East Lansing. 55th kind of deals with the out county. So that would be like Holt and Mason and so forth. There's 56, excuse me. There's also different circuits as well. In terms of what we are doing in 54A District Court, all criminal jury trials have been suspended. They are suspended until June 22nd, and right now our courts are working to reschedule all of our criminal jury trials. In terms of dealing with in-custody arraignments, again, unless someone is a risk to the community, unless we're dealing with a very serious crime, a lot of those that are accused with the crime are being released on PR bonds, of course, and they're given a new notice to appear at a later date. We're seeing a lot of our cases here at the city being rescheduled. Like other jurisdictions, especially in the Metro Detroit area, we too are implementing Zoom, not next week, but the following week, May 11th. Some of the assistant city attorneys, in addition to some of the assistant prosecuting attorneys, will be conducting pretrial conferences, pre-hearings, and other types of hearings via Zoom. The defense attorneys will have the opportunity to meet with their clients in a separate room. And then on the back end, both the prosecuting attorney and then the defense attorney will have the opportunity to both talk and possibly come up with some type of solution with the case, So we're going to be utilizing the different Zoom rooms here at 54A in the district court. In regards to our circuit courts, we have seen some things rescheduled, but more than likely, a lot of what we are seeing here in our circuit court is the use of Zoom as well. Things are still flowing as normal in that you can still file your documents. So you can file your responses to your lawsuits, to your motions and so forth. You can file them either electronically, you can mail them, or you can send them by via fax, just so that we are in compliance with the executive orders. Something that I do want to touch upon as well, the public may see signs outside of either their city halls or their courtroom buildings. The signs are now requiring masks here at our city hall. In lieu of the most recent executive order, which I think it was 2020-59, there is a requirement that the public, when they're entering the building, not only must they follow social distancing guidelines, but they also must wear a mask as well. So we are implementing that practice. As far as the personal protection orders that we see in our family courts, again, we are adhering to those guidelines as well. So those protection orders are being extended pursuant to, I think it's the executive order. I think it's executive order 2020-54, if I'm not mistaken. And those PPOs are extended until July 21st of 2020. And I just want to reiterate with the personal protection orders, just because there's an extension, it does not prohibit the objection to an extension. It does not prohibit a motion to modify or terminate, and it does not prohibit consent from the petitioner to terminate the personal protection order. Again, because we are in the midst of a pandemic, you're going to see many of the courts limiting access again to the courtroom. So they do not want any more than 10 persons coming to the courts. As you know, our courts here, both of our district courts and along with Ingham County, has been closed except under certain circumstances. So again, we're still adhering to the social distancing guidelines. I just want to make sure I'm touching on everything because I know it was bouncing around a little bit. Oh, very quickly, I don't have the opportunity to participate in mediation as much. I previously volunteered with the Center for Resolution Services here in the Lansing area. They too are shifting to more Zoom capabilities and Zoom hearings for their mediation. So I know that they will be reaching out to volunteers to with the center to handle a lot of those hearings, because they do handle a lot of the landlord tenant matters as well.
Thank you, Mary, for that update. The overall sentiment I heard was that everyone is adopting and adhering to the executive orders in most of the courts here in Michigan, if not all. The most recent change I just heard was the requirement for the mask in the buildings. So I'm not sure if people are aware of that. I did put it in the comments below so that people are aware that masks are required when you enter the court building. Is that everyone's understanding that now you have to wear a mask in order to enter the court buildings? Okay. And I think the other takeaway is the extension. I think that executive order is the extension of the PPOs until July. Current active PPOs are extended until July. And then another takeaway is that even when the courts resume, most hearings will be conducted via Zoom or some type of remote virtual mechanism. Is that correct?
Correct.
Okay. Well, we're 22 minutes in. Did anyone want to add anything regarding that we may not have addressed or that they feel that the public should know regarding the courts?
The only thing I would like to say, Chandrika, and I think this goes for all the panelists, keep checking the websites wherever you're doing business with. As you know, this whole pandemic and executive orders has just been fluid from day to day. There may be a change in what the governor orders or what one of our court administrators or chief judges orders. So I would just advise people to keep checking the websites for updates.
Thank you so much, Lisa. Yes, Mary.
I would also like to add, pardon the interruption. There are some members of the public that may or may not have access to Zoom or have the functionality. What I wanted to reiterate, something that our court is doing, because there are some individuals that may have problems with income tax or rudimentary traffic matters. In the event that they are unable to appear via Zoom, they will not be issued a failure to appear notice because of the pandemic, because we realize not everyone has access to similar types of resources. And again, this is a strange time that no one was prepared for. So you may see that in other jurisdictions. That's not an excuse to not appear for court, but in the event that you did not have access to Zoom and you were unrepresented, again, the court would not be issuing a failure to appear bench warrant because of that inability.
Gotcha. It's my understanding from using Zoom and having clients that are low income is that a lot of clients have smartphones, and if they just download the Zoom app, they'll have the ability to to actually appear via these hearings, but a lot of people don't understand about downloading the app. That's an option for them to actually download the app and just participate that way. It's just like any other device. So if you have an iPhone, it's like FaceTime. If you have an Android, it's like using Juvo or something of that nature. Does anyone have any insight as to how someone who is ESL, English as a second language, would go about utilizing the Zoom capabilities in addition to needing an interpreter?
I don't know, in addition to needing an interpreter, what they would need to do, but definitely we will provide an interpreter to be part of the series, to be part of the hearing. And if they need to have the confidential meetings, to go into the break rooms for that to occur.
We are also
Okay.
using the chat feature in our Zoom rooms. The attorneys sometimes, well, not sometimes, they issue an award. And just so there's no confusion between when it's actually entered and the award, we're using the chat feature in Zoom for that. So that might be another resource or tool that people could use to communicate while they're in the hearing room as well.
Thank you so much, ZENELL and Lisa. We're almost about to close this out. So ZENELL, if you could give your closing salutations, I appreciate it.
So as everyone's saying, we're building this as we're living it, basically. And definitely because of the Chief Judge, Judge Kinney, the various presiding judges and the administrators, and the commitment of staff and judicial partners, we've been able to do so much in such a short time. Our state court administrator, Tom Boyd, basically said we're taking 3 years worth of technology and learning it within 30 days. So I think that, you know, the court's doing pretty well. And definitely we appreciate an opportunity to share what we're doing so we can ensure the legal community has access and knowledge of what's going on as well. So thank you for having me.
Thank you so much, ZENELL. I appreciate you. Lisa?
So again, to reiterate, the Mediation Tribunal exists to be a service provider for our Wayne County courts. Wayne County Circuit Court is the largest court that we provide services for, but we have tried and we will continue to reinvent ourselves, as ZENELL suggested, in ways that we can continue providing services for the court, namely case evaluation, mediation, facilitation. So continue to check our website at mediationtribunal.org. We are moving remotely. We've got great people that have volunteered to be on the frontier of this and learn how to do remote facilitation and remote evaluation. And I think we'll get through this. We'll get through it.
Thank you so much, Lisa. Mary, would you like to close out?
Yes. Again, I want to thank you all for the opportunity to kind of give you some tidbits and give you some insight on what's going on here in the Lansing area. Very quickly, I just wanted to leave a few phone numbers. I didn't have a chance to do so earlier. In the event that some of our members of the viewing audience might have questions regarding the courts here, and they need to contact the courts for our general civil division. Our number is 517-483-6500. And again, that's for the Ingham County Circuit Court. For the probate cases, including the guardianships and the conservatorships, and the states are dealing with any types of cases with mental illness issues, the number is 517-483-6300. And for any matters involving the 54A District Court, the general court information line number is area code 517-483-4435. As the other speakers had reiterated, this is a challenging time. This is an unprecedented time. Not only have attorneys kind of had to shift hats and switch gears to keep up with the trend of things, but also the courts have also had to take a different approach. And even, you know, as the governor reevaluates whether, you know, when things are going to be reopened, the courts in the midst of following, what's going on here at the state, the courts are still going to continue utilizing the software. I know they already use the software remotely for many of their arraignments, but they're going to continue with the Zoom software in terms of conducting a lot of their hearings, just to minimize, the exposure and minimize the contact in terms of being in compliance with social distancing guidelines. So again, check out, lansingmi.gov, utilize the phone numbers, not just here, but if you have cases across the state, definitely take a look at the other courts' websites and call the phone numbers if you have questions. And again, I just want to thank you all for this opportunity.
Well, thank you all. Thank all of you ladies. I appreciate you for participating. You gave some great nuggets for the public to be able to use. The Black Women Lawyers Association appreciates you participating in the People's Law School, and thank you again.
Take care. Thank you.
All right, that's the end of our People's Law School State of the Court. We'll be loading back up with the People's Law School Educational and Juvenile Law with our panelists, Attorney Rita White and panelist Attorney Robin McCoy and Attorney Linda McGee. For those of you who may have questions for those attorneys coming up, I would encourage you to use the comment section to ask a question so that we can address it for you. This is the time for you to ask an attorney questions that are related to the law for free. We utilize the People's Law School to educate the general public regarding laws that affect them. And so this is the time for you guys to utilize this service. For those of you who know and those who don't know, a lot of people do not have access to justice, and we want to make sure that we can provide that to you. And this is one of the forms that we're using to do that. So I'm encouraging you to type in your questions so that when the panel is ready, they should be loading up at 12:35. It's now 12:32. The panel is ready, that they'll be here and available to answer your questions, and you'll get the information you need. Information is power, and we want you all to have the power that you need to be able to navigate this legal system, especially during these uncharted territory that we're currently experiencing with this pandemic. So get to typing and type those questions in so that the panel can address your issues. We'll be addressing juvenile law and education law, but the panel that we have is well versed in many areas of the law. So ask those questions, and we welcome your participation. Again, I'm Attorney Chandrika Simmons. I'm the previous president of the Black Women Lawyers Association. I'm the current treasurer, and I am facilitating the People's Law School presented by the Black Women Lawyers Association. We appreciate your participation as it relates to this program, and we're looking forward to you actively participating so that we can educate you on how to navigate the legal system with a little bit more ease than what you're currently experiencing. I'm just waiting for more attorneys to come into the room, and we'll be adding them shortly. If you have any questions regarding the legal system, we ask you ask those now in the comments. I see some questions popping up now, so we'll be ready for our panel in a minute. I am an attorney in private practice here in Oakland County. I practice civil litigation, employment law, family law, probate law, and contractual law. My website is lawchic.com. I'm available for your legal needs. You can call my office, 248-732-7559. We are open for business. We're conducting consultations via virtual online mechanisms. So if you want to do a free consultation, we're available for that as well. Again, I ask that you, if you have any questions for our attorneys, that you load those up in the comments section so that when the panel is ready, they're ready to go to answer your questions. For those who don't know, we just did a state of the court with the court executive administrator for Third Circuit Court, ZENELL Brown, and also the executive director of the mediation tribunal, Lisa Timmons, and an assistant City of Lansing attorney, Mary Bowens, who just gave you some tidbits regarding the state of the courts in this during this pandemic. That was helpful to you. It was absolutely helpful to me. For those you don't know, most hearings are being adjourned. You do not have to file motions for those. You will be receiving correspondence from the courts regarding those hearings. And most hearings will be via Zoom, so be prepared for that. Okay. It appears that our panel is ready. Welcome, Linda.
Good afternoon. How are you?
Attorney Linda McGee, I'm great.
Good.
Good afternoon, Attorney Rita White.
I can't.
And
Hello.
good afternoon. And good afternoon, Attorney Robin McCoy.
Hello, Attorney Simmons. How are you doing? And Attorney McGee.
Hi, Robin.
I'm awesome. Good to see you, ladies.
Hello.
All right, so we have our panel ready for our juvenile law, educational law series of the People's Law School. I'd like to welcome my panel, Attorney Linda McGee. Attorney Linda McGee, can you introduce yourself?
What was the question? I saw your lips moving, but I didn't hear anything.
I think she's asking you to introduce yourself. Oh, go ahead.
Oh, okay. I'm Attorney Linda McGee, and I'm from Michigan Children's Law Center. I am the one of two executive directors, and we have 12 attorneys that work with us as lawyer guardian ad litems. For people who don't know, our lawyer guardian ad litem is somebody who works with young people representing them in the foster care or child welfare system, as well as the juvenile justice system.
Thank you so much, Attorney McGee, for being with us. Attorney Rita White, can you introduce yourself?
Good afternoon, everyone. My name is Attorney Rita White. I am a private attorney. My primary practice is criminal defense law, appellate work, and I do handle child welfare matters where I primarily represent parents and mentally incapacitated adults along with children, but primarily parents. And I represent them in termination proceedings and temporary custody proceedings.
Thank you, Attorney White. Attorney Rita White is also the president of the Black Women Lawyers Association as well. Attorney Robin McCoy, can you introduce yourself, please?
Yes. Hello, everyone. This is Attorney Robin McCoy. I am a partner with the firm of McCoy and Associates, 734-769-0001. I'm also vice president of Black Women Lawyers of Michigan, as Attorney Simmons is our treasurer, and Attorney McGee is one of our members of Black Women Lawyers of Michigan. And I do criminal defense, family law, and I do educational advocacy.
Thank you so much, Robin. We have a few questions already queued up, so I'm going to start those questions off. I would ask that only one person from the panel answer the question, and we'll move on to the next question. So our first question is related to, let me pull it up. What is a pretrial conference? Attorney White, can you tell us what is a pretrial conference in Michigan?
If it's relating to a neglect proceeding, a pretrial conference is a conference where the Department of Health and Human Services has filed a petition against a parent alleging neglectful actions such as failure to protect, a child in relation to possible physical abuse, sexual abuse, environmental abuse, meaning that they're not able to reside in a environment that is safe and suitable for them, and enough to rise to the fact that they would have to be removed from the home. So what would happen is if an actual preliminary hearing, a petition is authorized, it will be placed for a pretrial hearing. And at the pretrial hearing is where the court would hear the allegations again. It would be actually before a referee or a judge. And then at that hearing, the parent would decide whether they want to proceed to trial to contest the allegations against them that have kept the children removed from them or the child removed from them, or if they want to make admissions. If it's a temporary custody petition, meaning the state just wants to remove the children, they do not want to terminate the rights, but they want to remove the children to provide services and maybe help rectify the home environment that caused the children to be removed, the parent would make admissions. And then they would be placed on a treatment plan, and that case would just continue for several hearings in a review hearing to evaluate the process and the progress of how the family is doing. So a pretrial is just mainly a hearing to either set a pretrial date, a trial date, to hold the hearing to determine the final determination of the matter, or if the family wants to make admissions to the petition and be placed on a treatment plan to work out their situation to be able to have their children back in the home.
Thank you, Attorney White. Attorney McGee, we have another question. Can you answer this? Can you go to jail at a pretrial? Please take your mic off of mute.
Oh, okay, it's not okay. Can you hear me?
Yes, ma'am. Can you go to jail at a pretrial?
Can I add to what Attorney White said, and then I can roll the answer to the next question into it? Because there's some, juvenile justice, and Attorney White gave a great explanation of what happens at a pretrial in child welfare cases. And we also have the delinquency cases at juvenile court, which include the children who are accused of an offense. In juvenile court, we don't call them crimes. If they were adults, that's what they would be called, but it's not in juvenile court. So if they're accused of committing some type of offense, they could also have a pretrial. There are two types of petitions. One is a not in custody petition, in which a juvenile or a child is notified through the mail that there is this petition, there is a court date, and you need to appear on this court date. We also have in custody petitions where a child is arrested or detained at the Wayne County Juvenile Court, and they have a preliminary hearing in those cases. So that in custody case will proceed to a pretrial, and the not in custody cases, I hope you can follow me because it's a lot and I'm trying to talk fast. That would also have a pretrial date. So either one, both of them actually would have a pretrial date that consists of meeting your attorney, possibly prior to the pretrial date or on that pretrial date, depending on the type of case that it is, and understanding what it is that your rights are, what the options are, what the potential consequences could be of making an admission, as Attorney White had explained in the child welfare case, or asking for a trial. We could ask for a jury trial, and you heard some people may or may not have heard in the previous panel discussion that we're not holding jury trials right now in the Wayne County Circuit Court, or you could ask for a bench trial and have a judge hear your case. So those are some of the things that an attorney, I'm an LGAL lawyer for children, that's what we would go over with our clients at a pretrial date. Now, if I represent a child in a juvenile justice case and he has some type of warrant out for his arrest, we call it a writ in Wayne County Juvenile Court, but if he has a writ out and he could be arrested, then yes, he could be detained, he could be arrested. If we get to the pretrial date and my client is out coming from the community and there's some evidence shown that he has been continuing to make bad decisions or not go to school or something that the prosecutor might bring up that would warrant, or making contact with a victim in a domestic violence or a criminal sexual conduct case, it's something that the prosecutor would bring up in those cases, then a judge could, or a referee could determine, okay, you are not doing well in the community is not safe with you there, you're not safe, and I'm going to detain you. So in a juvenile justice case, yes, you could be, if there are other things that are going on before we get to that pretrial date. In a child welfare case, Attorney Robin McCoy or Attorney White might be able to answer whether or not you could be arrested. The only time I've seen that is when a parent has had a warrant for their arrest in another matter, and they could possibly be arrested after juvenile court.
Attorney McGee, I just want to bring notice to you that there's some breakage in your microphone, so we couldn't really hear all that you were saying. But Attorney McCoy,
Okay.
so if you could fix that for me, Attorney McGee, while we're let Attorney McCoy tell us, can you go to jail at a pretrial?
Yes. So, you know, as far as a neglect proceeding, yes, as Attorney McGee indicated, you know, you can have a parent that, you know, they may look at and see if there's a warrant for their arrest, and then they can look and see if there's it'll be at the discretion of the court whether they decide. Some courts will say, okay, there's a warrant, we're going to take you into custody right now, and then, you know, like if it's Wayne County or Washtenaw County, if the place that has the warrant for you will come pick you up. Or some courts may inform, you know, the person and their attorney and say, hey, we're looking in the system, there's a warrant for your arrest, you need to go take care of that before you come back to court, because this is a problem, because, you know, that can affect whether a parent is able to you know, be able to take care of their child if they have an outstanding warrant. You know, and as far as a pretrial for a delinquency case, can a person, you know, be typically at a juvenile court, it'd be a minor. Can the person be arrested? I think or can they go to jail was the question. I think it depends on what happens. If you end up doing a plea to an offense, and that plea entails you going to be to the juvenile detention facility or to being locked up, then yes, you can go to jail. Typically, I would say most of the time at juvenile court, though, we'll do a plea, and then we'll come back for what's called the disposition. And then it's usually at the disposition phase, that's where they'll have a report. We'll talk about what's going on with the child, the background, mental health background, educational, things like that. And then it'll be up to the referee or the judge to decide whether they're going to lock the child up. Typically, I would say, though, at the juvenile court, they don't usually just lock children up. They try to work with them. Like, they do special programs. Like, some of the jurors will let the children write a again, it depends on the offense, what it is and the severity of the offense. But if it's like the first time that the child has come, and they might try to let them write a letter of apology, do community service, and then have probation. And then try to give them probation for a period of time, maybe 6 months, and then see how they're doing. If they do well, they just, you know, the case gets dismissed, everything's good. If they don't do well, or if they keep getting in trouble, that's where it could go from, it could just be regular probation to, it could be intensive probation, depending, you know, like if it's a severe offense, if it's like a armed robbery, carjacking, something like that, it could be intensive. Or it can, you know, it's like if you've had somebody that keeps coming through the system and they keep getting in trouble, and they poured resources into the community, then, you know, they could be more likely to get locked up if they keep getting in trouble and if they keep having a higher level of severity of offenses.
Thank you, Attorney McCoy, for that. We have another question. Can a judge dismiss a case before trial? Attorney White, can you answer that question for us?
Not like the other guy. Remember the other guy, I knew him. We all worked together.
As Attorney Rob McCoy had discussed, and Attorney McGee, a lot of these factors are based on a case-by-case method. It really depends on the facts and the circumstances underlying the case. Now, as a juvenile attorney and child welfare attorney, I was a prosecutor for several years at the Juvenile Justice Center down at Lincoln Hall of Justice. And when a case is filed, dismissing a case before trial, that will have to carry a lot of communication, negotiation, and addressing the actual facts of the case. The percentage of cases that are dismissed before trial, they're only dismissed before trial if there's some type of resolution to maybe dismiss one case with a plea to the other. To outright dismiss a case, a lot of times that really deals with what your case actually involves. If it's a matter that you're looking to maybe obtain an offer that eventually, if you plead guilty and the case eventually, as a result of an agreement with the prosecutor's office and the court, if you comply with the conditions that the court assesses, then the case will be dismissed. There will be no trial and the case could be dismissed. But a case outright being dismissed before trial, that would really carry, first of all, even getting to trial, that's a very, very difficult feat to attain, to have a case dismissed before trial. But if you do have a trial and let's say the trial is scheduled, the complainant, the victim, or the witness does not appear, or the prosecutor, for whatever reason, decides not to proceed, yes, it can be dismissed. But just to outright ask for a dismissal before trial, where there is still evidence to be placed against you, that would be very difficult. You would have to really work with your attorney and see how the matter could be negotiated to have your consequences offset, and to avoid a trial and have a dismissal, hopefully, eventually, through negotiations. That would be the only way a case could really be truly dismissed before trial, other than a witness not showing up.
Thank you, Attorney White. We have another question here. How many days do you have to appeal a case? Attorney McGee?
It depends on where you are. Well, we're talking about juvenile court. So you have 21 days to appeal a case after a judge has determined that, or made a determination or a finding on the case. You have 21 days. I will say that on a lot of the cases that could be appealed, which from my understanding, and Attorney White she does a lot of appeals, so she can chime in on this. But what I see is that not enough people appeal the cases. I mean, it doesn't hurt. You have a court-appointed attorney on the appeal, so I don't know why there aren't more. There are a lot. There are quite a few appeals, but I just would imagine that everybody who is interested, particularly in retaining the rights to their children, would appeal cases. But a lot of them don't. And again, I represent kids, so I'm not asking for more people to appeal these cases, because many times my clients, the ones that I represent, are in good homes. They are in homes that they've been in for 2 or 3 years, and perhaps the parent recognizes that I haven't, had my child in my care for quite some time. I really haven't rectified the situation. I'm still on drugs, or I'm still homeless with the same issues that led to my children being into care, and I don't care to really fight it anymore. So that could be, that could be a reason that there are not more appeals, but sometimes it doesn't surprise me. And can you hear me better in this room? You still can't hear me?
Wait a minute.
We can
hear you. We started off pretty good, and then it started to get staticky again. I think you answered the question, though, with the 21 days. Attorney McCoy, is that your understanding as well, the 21 days for the filing of an appeal in a juvenile case?
Yes, and I agree with Attorney McGee that more parents need to be filing appeals. It's because it's like, sometimes people need more time to get their lives in order, and the courts can traditionally be on a fast track, and there's some people that get their lives in order and they don't do it within the cookie cutter time frame that the court has, with the Benchfield legislation, all that kind of stuff. So I definitely think more parents need to be filing appeals. In some cases, more parents should be asking for jury trials. Some cases, because I've worked as a parent's attorney, and I worked for 12 and a half years with Michigan Children's Law Center representing kids. Now I'm back in private practice. And I will say there are some cases that are garbage cases that the parents should be asking for a jury trial, or asking for a bench trial. But then there are some cases, it's just like some of the criminal cases where it's like the person clearly they're in the wrong, and we need to be making admissions and hurrying up, like getting on track. I know what I do with a lot of my cases is I have like a checklist for the parents of things that I want them to do, just like on my criminal cases. And where I ask them, because we're as lawyers, it's a teamwork process as far as the lawyer and the client. And so we have the knowledge, we know what the process is, and we give clients tips, parents, like if it's an issue of like they don't have a job, we'll say, okay, when they need counseling, get the counseling, get the job, get a place to stay, get the resources. And sometimes you have workers that are great, that give them resources, that help them to get things in order. Sometimes the system is very slow, so some parents have to kind of do some things on their own or get resources on their own, and just be aggressive with trying to help their kids. So it's, just like I said before, it's like, it depends. It's a case by case basis. There are some cases that we've dealt with that have been severe, broken bones, 2 different occasions, and there's no explanation. And, and that's a problem. But then there's some cases where, like, physical discipline cases. My first, when I was in private practice, my first 3 jury trials were physical discipline cases, and I won all 3. Because it was garbage cases, and law says you can use reasonable force to discipline a child. But the way the system works is if you leave a mark on a child, then that's going to trigger, a case being open, and they'll investigate it. They'll decide whether they're going to substantiate it or not. And some cases, if it's not as severe, they'll resolve it outside of court if you just get some parenting classes on how to discipline your child. And then some cases, we've seen some of the more severe cases, with a baby, like with an iron. I had one with a child that had an iron mark on its stomach, and we didn't know what happened. And those are difficult cases. I would also say this, I can't say this enough. Be honest with your attorney, whether it's a parent's attorney like Attorney McGee or Attorney White. Attorney McGee represents the children and Attorney White represents the parents. Be honest with your attorney. We don't like surprises. We go into court, we represent what our clients tell us, and if the clients lie, and then we get out there and we make representations, and the judge or the prosecutor or the AG, the assistant attorney general, they see a lie, that's not going to go over well for the case. So do not lie, tell the truth, and try to have as much documented evidence of what you're doing, as far as you've got a job, pay stubs, a letter from an employer, you're doing counseling, mental health counseling or substance abuse counseling, because the judges and the referees, they're not going to just take your word at face value. They want evidence. They want documentation that what you say is true.
Thank you so much, Attorney McCoy. Attorney White, would you like to weigh in on that?
Yeah, just briefly, in terms of Attorney McGee and Attorney McCoy are correct in the fact that there is a 21-day period. Just be mindful that the 21-day period tolls from the time that the actual order is put in place by the judge. It would be a judge. So if you have a referee that enters the recommendation to terminate your rights or to remove your children from their care, then the actual, once the order is signed by the judge, then the 21-day period starts to toll that you have the time to request. If you are looking, because all parties basically under the child welfare statute would be entitled to an appointed attorney to handle their appellate matter, or you could hire an attorney to appeal your case. But what you would do is you would have 21 days to make that request to put in for your appeal. And then once within that 21 days you put in your request, then the attorney, either if you have an appointed attorney, will be appointed that case. And then once the attorney is appointed that case, that attorney then has a different timeline to actually file the appeal. And the timeline really runs with the time that they receive the full amount of transcripts that will actually are relevant to your case. And then that timeline, there's a specific timeline that the appellate attorney has from the time that they receive the last transcript to file their appeal against on your behalf. And so really the appellate attorney would be reviewing the entire transcripts from all of the review hearings, the pretrials, and determine if there were any errors that were committed during the process of your case. So really in terms of like if what the timeline is, you just have to make sure you make your request to appeal within 21 days.
Thank you so much, Attorney White.
You're
Can you
welcome.
answer this question regarding appeals? I mean, what's the difference between a jury trial and a bench trial?
I'll start with that. So a bench trial is a trial where you have the judge or the referee in a neglect proceeding. They are evaluating the case, and it starts, if it's a delinquency case, the prosecution, they'll call their witnesses, and then the defense will call their witnesses. The prosecution can have an opening statement, the defense can have an opening statement. So they do opening statements at the beginning. The prosecution calls their witnesses, the defense does a cross-examination of the prosecution witnesses. Then the defense, if they so choose, they can call witnesses, and then the prosecution will cross-examine the defense witnesses. Then there'll be closing argument, and then the referee or judge will make a decision. The distinction with a jury trial, we don't see them very often, I would say, for the neglect cases, but if you have a neglect jury trial, then you will have a jury there. And a jury will be listening to the evidence, deciding, whether there's been abuse. Like I said, with my parental discipline cases, there were allegations that are listed in the neglect petition. And so the jury was evaluating whether those allegations of abuse were true or not. And so you still have opening statements from either side, and you have, you still have it'll be, well, in Washtenaw County, it was the prosecutor's office. In Wayne County, it would be the assistant attorney general. They call witnesses, and I say the defense, but it'll be the respondents, the parent's attorney that'll ask questions, and you have a lawyer guardian ad litem too, which is what Attorney McGee does. She'll ask questions, and then the jury can make a decision about who the jury believes, and then it can, for a delinquency case, you would have it with a prosecutor asking the questions, and the defense attorney, which is what Attorney White, Attorney White and Attorney McGee both represent children on delinquency matters, so they'll be asking questions. And so we typically will see jury trials on some of the more severe cases, like on delinquency, like maybe an armed robbery, a criminal sexual conduct case, which is an alleged rape case. So some of the more severe cases will have jury trials, and they're before the judges. So I don't know if anybody else wants to comment on that.
I just wanted to piggyback, and I'm hoping everybody can hear me, but I wanted to piggyback on that and just add that a neglect jury trial would only address whether or not the court has jurisdiction. That's it. I mean, they don't go any further. The judge, if they do determine the court does have jurisdiction of that case, then that case still goes to the judge. Whereas a juvenile justice jury trial, the jury would determine whether or not our client, who is a child, is responsible for committing the offense. They make that, they make pretty much the whole determination, and then the judge determines what the sentencing or disposition should be, how they should be held responsible for being found responsible. Or the jury could determine that a child who's accused of an offense in juvenile justice is not responsible. That child goes on their merry way.
Okay, so the next question is, how long does an appeal take in the Court of Appeals? I guess I can answer that. Now, you have to be aware that again, this is a process where the appellate attorney will have to make sure they wait for all of the transcripts to receive the transcripts. And then upon receiving the transcripts, they have a period of time that they have to have the actual appeal filed. Once the appeal is filed, it really is up to the Court of Appeals. There's no exact timeline as to when they issue their order. It could be within 30 days. It could be within 60 days. So it wouldn't be more than a year, but it could be at least no later than at least 4 to 6 months. But also be aware that if this is a matter that is involving a termination of parental rights, the actual termination order is stayed, okay? So there is no termination that is actually put in place to finalize until the appeal is actually finalized and there's a decision that's been rendered. So that it's not saying that the child will be returned to the parent, but the actual order for the termination such as an adoption will not be able to proceed and go forth with until the appeal has been actually heard and determined. So in terms of the time it takes, it could be about from 3 to 6 months from the time that the appellate attorney files the actual appeal. Now, the next question is, what comes after an arraignment? McGee or Attorney McCoy, if you'd like to answer.
In juvenile court?
It's probably, I would assume, in juvenile court, since that's the main
We don't.
presentation today.
Unless somebody else has a different response, we don't. And feel free to add. We don't have the same language as we would in adult court, so we don't have arraignments. I saw a previous question that asked how many pretrials can you have right above that, and it depends because, and I don't know if that's what this person means by arraignment. Maybe they could clarify, but as far as the pretrials go, you could have multiple pretrials because if I come to court and I'm representing your son, daughter who has carrying a concealed weapon case, and I don't have any information from the prosecutor, I can't advise you. So I have to ask for another pretrial date so that I can get all of that information together. And in adult court, you would normally have that by the arraignment, which is why I'm trying to distinction. But we don't necessarily have arraignments. In the juvenile court, we can ask for a continued pretrial so that we could get all of the information together and then be able to advise you in between, negotiate with the prosecutor or make other arrangements.
Because I think in terms of the arraignment term, I think maybe if you are referring to the juvenile sector of what you're discussing, it could equate to what is called a preliminary hearing, and that's pretty much what would be kind of equivalent to would be equivalent to an arraignment, and that is when an actual juvenile is arrested and brought to the juvenile detention facility, and then their preliminary hearing is held to authorize the petition, and the petition is pretty much equivalent to a criminal charge against a person, but it's called a petition. And what happens is that a referee would hear the charges and then determine if it's enough to actually authorize the charges to proceed with the case. And then what would issue is if they're in the detention facility, which usually that's what happens if they're at the JDF facility, then what would happen is then bond would be addressed and it would be determined if they would be able to be released or have to remain in custody pending the case. So that is really what an arraignment would be, but not all juvenile individuals that are charged with juvenile cases would have a preliminary hearing of that sort because some are not in custody at the juvenile hall to have a hearing such as that. The next question is, how do I file a motion in court in Michigan? Either of you?
Well, I'll say, I mean, I know we're talking today about juvenile court. So if you're going to file a motion at the juvenile court, I mean, prior to the pandemic, you would draft up the motion and you would go to the third floor and at the Lincoln Hall of Justice, you would file it. You would want to make sure that you have copies again, it depends on who's filing the motion. If it's the parent, in a neglect case, you're having a, you want to have multiple copies. You want to have a copy for the assistant attorney general. You want to have a copy for the court, whether it's the referee or the judge. You want to have a copy for the lawyer, guardian ad litem. And then you want to file it with the court. You want to get it stamped, and then you can email it or mail it out to the parties with the proof of service, and you will have a notice of hearing. Set it for a date. If it's a delinquencies matter, you would file it same place, third floor. I mean, now I think they are trying to work on that. No, that's been one of the concerns I've heard was from some of the attorneys at the juvenile court, is that they want to be able to have Zoom capacity to file motions, because they're saying that there could be some emergencies that arise during the pandemic. But if it's a delinquency matter, same thing. You go to the third floor, you file it, you have to serve it, you have to give a copy to the prosecutor, and you have to file a copy with the court. Make sure you do a notice of hearing, make sure you get it time stamped, and make sure that it's all, everybody's on the same page. That other question about arraignment, I don't know if somebody was talking about a criminal case. So if you have an arraignment on a criminal case, that's like a felony case, you'll have an arraignment, and that typically will be at the district court, and then you'll come in, and then you can have what's called a probable cause conference, a preliminary exam at the district court, and then it could be bound over to the circuit court and for another arraignment before a circuit court judge, and it can go on track that's for a felony. That's typically where we hear arraignment, or we'll hear it on a misdemeanor case. We'll hear somebody will have an arraignment, and then they'll have a pretrial, and then they can decide whether they're going to have a bench trial, a jury trial. So that's typically where we hear the word arraignment. And then I saw an earlier question that was saying, how many pretrials can a person have? Typically there's no exact limit, but the judges do have a time frame that they have to follow. Like if it's a neglect case or delinquency case, so they'll typically they can have a few pre-trials because maybe they're trying to get information or trying to work out a resolution, but eventually they're going to put it on track. For a neglect case, they'll probably set it for a trial date, or delinquency as well, either a bench trial or a jury trial, because the judges and the referees have to maintain a timeline consistent with the state court administrator's office.
Okay, so Attorney McGee, I'm going to ask you present the next question to you. Do juvenile courts lose jurisdiction over juvenile offenders when they turn 18 years old?
Simple answer, no, they don't. Most juvenile cases, once a child has been adjudicated, would end at 19 years old. That's when jurisdiction would end. Unless it's a capital case, and it could be extended until they're 21 years old, and that will require a hearing. So if it's what we would kind of call a misdemeanor or a low-level felony in adult court, if that's what the child has been adjudicated on or found responsible for, then jurisdiction ends at 19.
Okay, explain what is a designated case?
A designated case is one where it's a capital case, and it could be designated as an adult case, not necessarily just it could be a juvenile, as in child under 17 years old, but the child is being charged as an adult, and it's been designated to the adult court.
Okay. So the nethe question is, I'm going to farm this out to either of you. Are delinquency hearings confidential?
No, all the hearings can be public hearings. Attorneys can file motions to make it a private hearing. You can file a motion to ask that the court hearing be closed. Most likely it's not going to be closed. And you see that in cases that involve criminal sexual conduct, when a child has been accused of sexually assaulting a younger child, then some attorneys will ask that the proceedings be closed. But to my knowledge, there's not a court rule that really allows that. Okay. Attorney, have you experienced anything different?
The hearings are open to they're open to the public if you're there. And yeah, I think you can, if you are concerned about the fact that your client is a minor, it's delicate, you can file a motion. I know Attorney McGee and I were talking about earlier about apparently in some of the other courts, they're doing YouTube hearings, and we as attorneys do have concerns about putting some of these hearings on YouTube, because it would be for whether it's for a minor or an adult, because under the law you're innocent until proven guilty. So you could have a proceeding, you could be charged with something and be innocent, and the case gets dismissed, and then a future employer could look on YouTube, put your name in there, and try and deny you a job, or even a future, if you're trying to apply for college or something, they could deny you based on something that was false that got dismissed. And so I know we said we are going to look into that to make sure that people's rights are protected, because you are innocent till proven guilty. And I know that's what we've all of us have had discussions, and I do the workshops on expungement. That's the issue. We talk about it. Even if you do something, you make a mistake, and you do everything the court asks you to do, you should be able to get your record cleared and be able to go to college, get a job in the future, and not have it stick with you for the rest of your life.
Right.
The next question is, what are the upper and lower ages of delinquency and status offense jurisdiction? Attorney McGee?
I wasn't really clear on what that meant, upper and lower ages of delinquency. I mean, you can be charged as a delinquent youth up until your 17th birthday, and then you are charged as an adult until the law changes. As far as status offenses, you can be accused of a status offense right up until 16 years old. And status offense, just for anybody who is not sure what that is, those are offenses that if you were charged, you could not be charged as an adult for those offenses, like being incorrigible. Incorrigibility is an offense that basically says you're not following the directions of your home, i.e., staying out past curfew, not doing what your parents tell you to do, that kind of thing. Truancy from school, you couldn't be charged with that as an adult. And that's a status offense. What other status offenses are there? I'm trying to think off the top of my head, but those are two good examples of what we see in the juvenile court, and they can be charged right up until 16 years old. And I mean, if you're looking for the lower age, I've not seen any below 10, because if you're being accused of being truant from school, that's really a parental issue. That at 10 years old, 11 years old, 12 years old, that's not on the child. So there is such an offense called educational neglect on the neglect child welfare side. We don't see a lot of that in Wayne County, but if somebody is not going to school and they're under 13, it's usually because of the parent. I have seen 13-year-old children who are accused of being truant from school, and typically incorrigibility comes in at about 13 and up. But I have had 10 and 11-year-olds who have been charged with being incorrigible. One of them, her parents brought her in and said that she would not do the dishes, that she would not come straight home from school, and they did not approve of the friends that she had that she talked to on the phone. So, of course, as her attorney, I did not think that the judge should find that she was incorrigible based on those, because I've seen so many worse things, but it was subjective. That was their definition of incorrigible, and the prosecutor charged it. My client ended up detained because everybody other than me, of course, thought that she should be taught a lesson. And when she was detained for 2 weeks, it fell on the Halloween. It fell during Halloween that she was detained. So when we came back the following week, she did not want to leave the Wayne County Juvenile Detention Facility because they were having a Halloween party that she was going to miss, and she had never had so many great friends in her life. Told me, I mean, to me, that spoke volumes about her home, not necessarily about her, because most of our clients, and I think both of you would agree, most of our clients want to get out of the Wayne County Detention Facility.
Oh, yeah.
She didn't want to leave.
Yeah, I would say for status offenses, I mean, typically it's like what Attorney McGee has said, it's truancy. It can involve running away from home, curfew violations, alcohol use. I mean, truancy. I've had kids as young. I've had like probably as young as 10 years old. You know, and sometimes you have to look at with the kids, like what is the actual rationale for why are they truant? You know, is it a matter of some kids and maybe they're showing up at the school, but they're not showing up at the classes and they're hanging out in the hallway, or some kids are not showing up. I've had some kids in the past where they have health challenges. And what we say to the parents is, okay, you need to get, if they've been missing school, and there should be documentation of that they have medical issues. Some kids have social anxiety. It may be a matter of trying to set it up where they can go to homeschool as opposed to being in a regular school where they're expected to be there. Some of the kids, you know, with that, like they maybe they just don't want to go to school, and the parents are having difficulties. So that's where they might, if the parents are having difficulties with the kids in the home and in the school, that's where they might file for incorrigibility. And I know that the court has a specialized program with the mental health docket where they will, if the kids are having mental health issues, they try to get an assessment clinic and get them a psychiatrist with medicine and a therapist. And then the work I used to do as an educational advocate at the court is I would help parents, you know, where, you know, we would try to get at the root cause. Like if a child, if it's suspected they have a disability, I would help the parent to write a letter to request what's called an IEP, an individualized education plan. The school, after you write that letter, they have up to 30 days to go ahead and set up the meeting and look at, we have to do an evaluation to see if the child has a disability. If they have a disability, then they have to go ahead and create that IEP. And then for some of the kids that may have behavioral issues, we would also request what's called a BIP, or a behavioral intervention plan, where they will do an assessment. And if the child is having some behavioral issues that are connected to their disability, we put together a plan of how is the school going to cope with those issues. You know, there's been this issue about the school to prison pipeline. Some of the schools, like I know when Attorney White and I were younger, I know my experience, the schools didn't just call the police on kids like they do now. They would handle, like we had teachers that typically would handle things and fights, little things like that. They would handle it. They wouldn't call the police. We didn't have, I know I went to Catholic school. We didn't have a resource officer. The teacher was like the enforcer and handled things. But today you have them, they'll call the police, especially disproportionately on Black, Native American, Hispanic children. And so as educational advocates, what we would do is go in and help the parents to just make sure that the kids are getting the right supports and that the schools are trying to work with the kids in the schools and give them the right supports and services, as opposed to throwing them over to the juvenile court, and where they could run the risk of getting a record and then graduating to the adult court. And then when they grow out of their immaturity or their behaviors, then they have a record. So we try to do damage control and prevent them from having a record. I mean, science has shown the adult brain doesn't fully mature to the age of 25. So we want to make sure that we're making sure that the young people get all the supports they need so they can be successful.
Okay, so the next question is, what is the youngest age that a juvenile can be transferred to a criminal court for trial to be tried as an adult? This matter is, again, the prosecutor would be determining whether they will be actually filing this case and recommending this case to be a designated case. Now, there is, in terms of Michigan, I believe that the minimum is 14 years old, that a person can be, if a person is accused of an act that is committed by an adult, that would be a felony, the juvenile court can waive jurisdiction and allow the offender to be tried as an adult. So I believe 14 years old is the minimum age that a person could be actually tried under the designated as an adult.
Yeah, I would say I have to look that up. I can't say it off the top of my head for Michigan. I mean, I know typically I will at Attorney White and we'll see kids that are like, and I'm looking up here. It says in Michigan, if you're 17 years of age or older and you get charged with an offense, you can be charged as an adult. It says if you are under the age of 17, you'll be tried in juvenile court unless the offense is very serious or other factors convince the court you should be tried as an adult. I know I typically at Frank Murphy, I've seen kids that are 17 and up. Have I seen 16 or something like that? Sometimes, not usually. Usually I see 17. And I mean, there's some kids that we have at the juvenile court, they'll stick. It depends. The prosecution has that discretion. I know I've been reading Ben Crump's book, The Legalized Genocide of Colored People. That's one of the things that he takes issue with, is that there are prosecutors that in some places, and here too in Michigan, that are disproportionately making that option to charge minors as adults. And there's also that Brian Stevenson has the Equal Justice Initiative, and he has the book Just Mercy and the movie, where he's talking about how in Michigan specifically, but other states as well, have had a history of charging disproportionately Black children as adults, and then getting them being sentenced to life in prison. And I know he took it to the Supreme Court, and there have been some cases where they've served a long period of time, they've improved themselves, and they've been released. And then I know there have been some issues though with our Wayne County prosecutor and being resistant to giving consideration to more people who were charged as a juvenile and given a life offense to letting them out. So that's why we've got elections, and we need to be mindful of the current prosecutor. The public, we turn that back to the public. The public should be out there asking the current prosecutor, what efforts is she making to ensure that there's criminal justice reform, and also avoiding the school to prison pipeline for Black children, because Black, Hispanic, Native American children are disproportionately caught up in the system in the prison industrial complex.
So Robin, the next question is, can police question a minor without a parent's consent in Michigan?
See, unfortunately, they can. That is a question that I, typically will deal with when I've done my program on what to do when stopped by the police. I've brought in Attorney White as one of our expert panelists to talk about this issue as well. There's no rule saying that they can. I mean, what they can do is they can. I tell parents and children, ask for a support person. You can request. Like I've had some cases where I've had some of my kids that have disabilities. So I wrote a letter to the school, and I basically said, if there's any issues that come up, we want to have a parent there, at least a parent. From my perspective, because I think we all would agree, you have children now. There are laws that were put in place to charge adults, but then you have laws now that are being put in place to charge minors. And if you're going to charge somebody with an offense that could be on their record when they're an adult, I had a couple of young people that I've mentored that have tried to get into college, and then their juvenile record has followed them. So if you're going to have something that severe, I think you should have a right to an attorney there. But at the bare minimum, you should ask to have a parent there. And I'll say this to parents. I would often see I started in Washtenaw County. I'd often see mothers, typically African-American mothers, that would say to their kids, well, just go ahead and fess up and tell everything. And I'm like, okay, fess up and tell everything, but tell it to your parents. Tell your parents the truth and tell your lawyer the truth. And then we as lawyers can help make the decision of whether we want to give a statement to the police. I've had some people call my office and they're like, well, the police want, like I have one now. They asked me, they're like, well, we want to talk to your client. And my client has some mental health issues. And I'm like, I talked to my client. I'm like, no, I don't think we should give them a statement because we don't want to help them to make a case against you. Let's just see what evidence they have, whether it's going to stick. I had another case with a young man. He was 14 and he said that he got caught up with another little girl who was 14 and they were intimate with each other. He said she initiated it. And then the mother and the child came in and they asked me, they told me the whole story and they said, well, the police want to talk to us. And I said, no, I wrote a letter to the police. I said, I'm representing this person. I understand you want to talk to them. You can have us come in if you want, but I'm going to advise my client not to say anything because I'm not going to try to help you to create a case where there is no case. And, some people, because in Michigan, the law says you can have consensual sex at the age of 16. So if a person is 14, then with a 16-year-old, then that's a problem. But one of the points that in that case is that if they're both 14, neither one of them can consent. So it's really for the police to be saying, oh, we're going to go after the male because he, you know, he initiated this. And then my client said it wasn't even him, it was the young lady. But I just told my clients, don't say anything. And, you know, that was a couple of years ago. I haven't heard anything. So I just caution, I tell people to zip it, you know, tell the truth to your parents and tell the truth to your lawyer. Cause like I said, Attorney McGee, Attorney White, we probably can give you countless stories where we go in there, we make representations to the courts, and then come to find out our client is lying. And then we look foolish, and that's not cool. We went to law school, we went to college, we worked very hard to do what we do. We want to be honest with the court and with the prosecution, all of that. We don't want to be going out there putting some garbage out there that our client has told us. And so that's why a lot of times we'll say, my client has indicated, you know, this is my understanding, because clients lie. And I know that Detective Brian Fountain, who does the What to Do When Stopped by the Police program with me, he talked about a case with a young man that lied to his parents, lied to the lawyer, and then he ended up going to prison for life. And he had just told the truth, we probably could have avoided or at least reduced his time.
Okay, so the next question is, what happens if the court finds a juvenile guilty? Attorney McGee?
If the juvenile court finds that a young person is responsible, because again, we use different language, and I know everybody doesn't, you know, if you don't practice there, you don't realize that. But if a juvenile court finds that a young person is responsible for committing offense, it depends on the offense, because there are some offenses, well, these are the three options, the main options. One, a young person can be warned and dismissed, and that's, you know, usually reserved for somebody who is there for the first time on a minor offense, such as assault and battery, retail fraud, you know, something very, very minor. A judge may say, hey, you know what? You're doing great. Your parents don't have any complaints. I'm going to warn you and dismiss this case. Do not come back here again. Another option for a juvenile judge or referee is to place a child on probation, and that is usually reserved for when they find that some supervision, some level of supervision is necessary. There are two types of probation in Wayne County, and that's probation level 1 and probation level 2. If you're on probation level 1, you are in your home. You meet with the juvenile court probation officer once a month. They go to your school, they check up on you, and after a period of 6 to 9 months, typically, if the child is doing what they're supposed to do, the case is dismissed. Probation level 2 is when a judge or referee determines that you are not going to you're not going to do well being in your home. You need a much stricter level of probation, and you need to be in a placement. And that's usually a boys' home or a girls' home. We call them residential placements. And that is when you are, it's kind of, I mean, some people call it juvie jail, because you are supervised 24 hours a day. And those are normally, those decisions are normally made when a young person has had multiple opportunities to show that they could be compliant in the community, or their parent is telling the judge that there's something going on in the background that that the judge doesn't know about. As a lawyer for the child, we try to bring in as much information as possible that supports our clients being in the community on probation or having the case warned and dismissed. So those are the three basic things that could happen. We could also ask, and I think this question came up earlier, or the response did, we could ask that the case be dismissed prior to either of those happening. And that's basically a plea under advisement. If my client says, hey, okay, I hit the girl at school and I shouldn't have hit the girl at school, but I've got straight A's, you know, I've got all these things I'm doing in the community, I'm doing this on the football team, I got this coach that's my mentor, or whatever the case may be, we could argue that this should be a plea under advisement. There are other options, diversion options within juvenile court, and I didn't want to get into all of that, but I think you probably have a good idea of what can happen.
So the next question is, this person lives in Michigan and they're 35 years old. I was barely talking to a 17-year-old. Can I get into trouble?
I was barely talking. What?
Like what, Mia? What type of talking were you talking? Like going further than a talking, or
For me,
I'll start. Okay. The age of consent in Michigan is 16, but it depends on what the relationship is. If you're a teacher, you can't be, and you're teaching in a high school or a coach. It depends on the relationship. You can't use your relationship, if a certain kind of relationship of authority over somebody that's younger. So 16 is the age of consent. If you just go up and you talk to a 17-year-old, and you're not in a position of authority over them, no. But I would just be careful. I would just say, just be careful. 16 is the age of consent in Michigan. If you're a teacher, don't do it, because you're gonna catch a case. If you're an employer, you can catch a case, sexual harassment.
Okay, so my 17-year-old daughter was on camera at school, and she pushed her 16-year-old boyfriend. Can she be arrested?
is he? I mean, is he? What? I guess I need more information before I could answer that. Was it an aggressive? Were they fighting? Did he call the police? How did this lead to a potential offense?
Yes, it really depends on, if the police are called, if the boyfriend calls the police or the school calls the police based on observing the video, because be mindful that even if a person's pushed, the person in and of themselves a case does not have to be instituted just by that person who was the victim. If a third party, such as the school, observes it, they can call the police. And if the police observe it and they believe this is enough to then send to the prosecutor's office, if the prosecutor's office reviews the police report that the police department writes up regarding this push over the video and on video, and believe that that's enough to proceed with actual charges against the person, then yes, the person can be charged. But again, it would be up to the prosecutor's office to determine whether, after especially most likely talking with the alleged victim, if it's something enough to go forward with. So it would be up to the prosecutor's office to determine whether there's charges filed. So the next question is, do parents pay for juvenile detention? Either one of you?
In Wayne County, most parents, I've not seen any parents pay for placement. I believe there's a scale, and it depends on the level of ability to pay. But because most of the Wayne County parents are not able to pay for anything, I'm pretty sure they don't pay for detention. I have heard in other jurisdictions where there is a fee. So I can only speak for Wayne County.
Okay. Next question is, if a child is on probation, can the school teachers contact via phone, email, messaging their probation office?
I would say, I'll start with that. Typically, I don't see it where a teacher will, because the teachers have rules and, about they can't just go, the teacher is supposed to be giving information about the child to the parent, and the child has a right to privacy. So it's not something like, I guess I would need to know a little bit more, but I'm saying if we're going with this, like maybe a child is acting up and the teacher is like, this child is acting up, I want to call the probation. It doesn't usually happen that way. Usually the teacher should convey that to the parent. I typically see the reverse of it, like with the mental health court, where maybe we'll have a probation officer and the educational advocate, and we are all talking. We form a team where it's the parent, it's the child, it's the teacher, and probation, and everybody signs a release, so that basically the parents sign a release to permit the teacher and probation and the educational advocate to all communicate. And it'll be different than regular court. Regular court might be every 3 months you come and check in on a child and see how they're doing in school. But if it's a child that has a disability or some mental health issue, struggles in schools, things like that, we will come back, the mental health court, it'll be like a monthly basis that we actually come into court, and we'll have case conferences. We'll talk about the case, and then we'll go in front of the judge, the referee, or the judge, and we'll see how the child is doing. And it's a specialized program. So if the child is doing well, then the child could have their case. If it's a delinquency, it's a incorrigibility case, it could be dismissed without a record. If the child is not doing well, we try to take a more progressive docket where we're trying to give services to the child and the parent and the community. And if you can, if you can find out what's going on, if it's a mental health issue or medicine, we try to work with the child. And some kids, they do well, they graduate successfully from the program from a year or 2 years. Some kids go the other way. If they're really messing up, they could just be spun off to the regular docket with a judge or a referee, or they could be graduated from level 1 probation to level 2. But just back to the original question, a teacher can't just bust out and call somebody's probation, because that would be a violation of that student's right to privacy. I would say start with the parent, or get a release from the parent. Don't just try to see if you can get the parent to work it out.
Okay, so the next question is, can Attorney McGee, can an adult above the age of 21 be charged for second-degree sexual assault that they committed at age 16 in Michigan?
Can they be charged? They can be charged. I have a question. I have a couple of questions, though, at least one. Was there a warrant? Was there a warrant? Was there a charge originally when the child was 16, or the 21-year-old was 16, 17, or previously, and this 21-year-old is just answering for that charge, or is this a brand new charge? And if you could put it in the comments, I think it would just help me.
Yeah.
This is something I think that, because Attorney McCoy, and I did practice in adult court as well, but I think that this is something that we would need to get more information about.
Yes.
Want to call. I know Attorney McCoy gave her number. Attorney White, I'm not sure if you did, but we would probably need to talk a little bit more privately.
Yes, because there are cases, such as I do even have cases on appeal where a person was 50 years old, and he was charged with a case where that was allegedly committed when he was 21. So it depends, because with sexual assault cases, the statute of limitations, it's very wide. So we definitely would have to receive more specificity in terms of your questioning, so we can really answer it with more specifics. Okay, so the next question is, I'm 17. My parents want to put a restraining order on my boyfriend. He's 19. He has done nothing wrong. Can they do that? Question.
Is the restraining order, the parents want a restraining order so that he won't come near them? I'm assuming it's so that he won't go near the 17-year-old, but you have to show that there's some threat or some fear of harm, and I don't, again, have enough information to know if they're able to show that. Did he threaten to blow up the house? Did he come over and break out all the windows? Is there something, you said that you, as a 17-year-old, say that he's done nothing wrong, but what do your parents say?
Yeah, I would say on that question, a person, a parent, if you're living in the home with your parents, and if you are, if your boyfriend has made threats towards you, or physically assaulted you, and the police have been called, or even if he's physically assaulted you and you're living in your parents' home, your parents they can go over to the 9th floor of the Coleman Young building. They can fill out a request for him to be restrained from coming over from calling, texting to the home. But typically they don't just give restraining orders just to give them just because they don't like your boyfriend. Like maybe they don't like him, but if he's been violent, if he's been harassing to either you or to them through social media, like texting, phone calls, if they have records, if they have documented evidence, they can do that. And, the only thing I could say is if you're with, again, I think we need a little bit more information. I'm not trying to get in any parents' situation, but if you're upset about that and other issues with your parents, you may want to look at filing a petition for emancipation But again, I think that would be a question for you to reach out to one of us to talk, give us some more specifics. And my number is 734-769-0001. So 3 zeros and a 1. And then my email is rlmlaw35@gmail. And it's RLM as in Mary Law at 35@gmail.
Okay, now speaking of the term that you just mentioned, brought up, emancipation, Attorney McCoy, the next question was, I'm sorry, at what age can a child legally leave home in Michigan?
I'm starting to think these are all from the same person. But at 18, at 17, really, DHS is not looking for you. CPS is generally not looking for anybody that's 17 years old once they leave home, or there's a neglect petition or something like that that's filed. Although there is a push for us to do more with the 17-year-olds, but you can leave at 18 years old and completely legally. At 17 years old, technically, somebody should be looking for you because child welfare goes up until the age of 18 years old.
Okay. Next question is, what rights do juveniles have if there is a trial?
I can start. If you have a trial, we go over rights. Like, we go over rights when people do a plea. We'll say, you have a right to a trial. You have, if you go to trial, you have the right to remain silent. You have the right to call witnesses on your behalf. You don't have to testify at trial if you don't want to. You can plead the fifth if you are, but typically you don't. What I'll say is, defense attorneys, we don't always call our clients. That's why it's really important that you tell your client the truth. So we kind of look at cases on a case-by-case situation. Some cases where if it's a he said, she said, like if somebody says you did something and you're saying you didn't, you might be the best defense. And assuming you can get up there and dress properly, your attorney has you going up there and you're giving a clear statement of what happened. But sometimes you won't testify. If you get up there, you're being rude to the jurist, the prosecutor, the defense attorney. Sometimes we may just have it go based on, sometimes it could be the prosecution doesn't have the strongest case. So we're not going to call you, or we may not call witnesses because we just let the judge or the referee see how weak the case is. So it really depends. It's a case-by-case basis. But yeah, you have rights at trial. That's why you really want to make sure as early as possible that you talk with your attorney. You should have, your attorney should give you discovery. So you can, what I typically do, I think we all do, is we get the discovery, we give it to the client. What I'll do with my clients, I'll have them read the discovery. I'll go over it. Sometimes I'll have them write up maybe a 1-page response just for myself and the client, not for the other side, to get a feel for what happened. And then we decide from there, what are we going to do? We're going to plead, or we're going to go to trial. Oftentimes it could be a plea, because if the person is like, okay, I did it, and there's no real evidence to help them or defend them, it'll be a plea. But then there are some cases where we'll take it to trial. Just depends on what the facts are.
Okay, so the next question, I can answer this or start the answer with this. My son is currently on juvenile probation and would like to live with his dad in a different county. What can we do? So the first thing that the parent or the juvenile should do is contact their probation officer. Ask their probation officer, make a request, indicate, listen, I would like to see if I can go live with my dad. So what will happen is then the probation department would basically either say, no, I'm going to completely object to that, I'm not going to agree, or they may say, okay, let's look and see if we can do this. And what would happen is then they would ask for probably see if they can get an order from the court, or sometimes probation officers can do them themselves, but most likely an order from the court to have their probation transferred to the other county. And the other county would have to then be communicated with, of course, before the transfer, to determine if the actual probation can be transferred to the other counties. So we've seen in adult cases, in juvenile cases, where kids have not decided, but have wanted to move maybe with a parent in Florida. then communication to Florida is put in place, and it's communicated as to whether the probation would be able to be transferred there. And that's happened many times, especially in the adult court. So that's all, it's mainly communication. Communicate with the juvenile probation officer first and let them know what the deal is. And then the process can hopefully start to have the probation move to the other county. So the next question is, I believe that this is a probate-related matter. Where can I apply to be my grandmother's guardian? I'm already her POA, but I am told that guardianship cases are different than POA matters.
I think you need a probate attorney to answer that in more detail. My experience with power of attorney is that if there is a provision that it survives a disability, that you don't need a guardianship, but I'm not a probate attorney. Perhaps there is something that you can do as a guardian that you can't do as a power of attorney.
Yeah, our firm, we handle probate, and we'll help people to draft the durable power of attorney for health and finances. And then it depends on what you're trying to do. If you're wanting to go more than the constraints of those documents, then you can file a petition for a conservatorship or a guardianship at the probate court. So again, I know we're getting told to wrap it up. So my number is 734-769-0001. And again, my email is email is rlmlaw35@gmail.com. The website's McCoy & Associates. I also have educational videos on Robin Legal, Robin with the Y Legal. And then, you can email me, or I don't know if Attorney White does any, do you do any probate matters or?
Minimal. I do not practice a lot of probate, so okay. Very minimal. So Attorney McGee, would you like to give your final statements?
Yes, again, I'm Attorney Linda McGee, and I've been practicing in the Wayne County Juvenile Court upwards of 20 years. Now I'm working with Michigan Children's Law Center as a co-executive director. And as such, not only do we represent children who are in the court system, but we want to make sure that they're okay outside of the court system. And with COVID-19, we have been working very, very hard to make sure that our young people in the juvenile detention facility have been released or transferred to where they need to go. We are also checking on our children or our clients in the child welfare system to make sure that their needs are being met and the services have not discontinued, that they are visiting with their parents, with their siblings, and that they receive resources. I did want to make note that if you believe that there is a child who's being abused or neglected during COVID-19 and the courts are not open right now, you don't know where to go, I do want to give you the phone number for Child Protective Services, which is 855-444-3911. I will also type that into the comments. There are housing resources for young people who are in college and still in foster care and have been kicked out of their colleges, basically because of COVID-19. So they had nowhere to go, but there are housing resources. If you know somebody in that position, contact Miracle Norrid at 734-858-8264 or Park West Foundation, who is making sure that these young people have food, hygiene products, clothing, and housing. And you can reach Saba Gabrai at parkwestfoundation.org. One additional resource is for drug treatment, alcohol treatment, resources for children, which you can contact Gerald Wade at a substance abuse organization. His number is 313-868-1340, and his extension is 109. I just want to remind everybody, we always hear in the news about the elderly being affected by this, the homeless being affected by COVID-19, the immigrants being affected, but we need to also think about children in juvenile justice and children in child welfare, AKA foster children. And thank you so much, Black Women Lawyers Association of Michigan, for having me on your panel. I look forward to doing this again.
Thank you, Attorney McGee. Attorney McCoy. It's been a pleasure to work with the Black Women Lawyers Association for actually putting this matter on. And these two dynamic attorneys, I worked with them for many years, and they are some of the most best dynamic attorneys that I've worked with in my life. So I really appreciate everyone tuning in. I really appreciate everyone tuning in to this presentation. As Attorney McGee and McCoy had indicated, this is a very crucial time and area of the law that we need to pay special attention to. Yes, the elderly, yes, we have a lot of people affected, but we need to make sure we also don't forget our children. Our children are very important, and we need to make sure through all of this pandemic, we need to make sure everyone is protected and everyone is very refreshed and updated on the law. So again, my name is Attorney Rita White. I am the president of the Black Women Lawyers Association. I can be reached, my primary practice is in Wayne County. I have an office in Plymouth, Michigan, and I can be reached at 734-334-3236. And again, I appreciate all of you who have tuned into this child welfare and state of the court presentation of the People's Law School and put on and sponsored by the Black Women Lawyers Association. And I hope you all stay safe and have a great day. Thank you so much.
Thank you, Rita. Thank you,
Thank
Jen.
you. No, thank you.
All right. See y'all later.